broadcasting and streaming live all across America. This is HomeTalkUSA with Michael King, where we will discuss topics pertaining to your home with industry-leading experts. Michael King is a licensed general contractor with more than 30 years of experience in home improvements and the author of Contracting with the King. Join us this hour for our segment Invent America with your co-host, the Inventor Lady, Rita Crompton. Discover what's next in the home improvement industry and explore new products and innovations. Or if you have that next great big idea, learn what it takes to bring your invention to the world as Michael King and Rita Crompton talk to America's inventors and innovators. Remember, the America of tomorrow is being invented today. We invite you to visit us at HomeTalkUSA.com, one of the best resources for home improvement information around today. Your best life begins with your best home, and there's no place like Home Talk. That's HomeTalkUSA.com. And now, we proudly present Invent America from the #1 home improvement radio program in the country, Home Talk USA, with your host, the Cajun contractor, Michael King, and his co-host, the Inventor Lady, Rita Crompton.
Yahee! Welcome back. That's right, to a new hour of the very best of home improvement information and education. This is the Invent America show, part of the Home Talk USA family. Welcome all of you. And now I'd like to welcome my guest, my sidekick. They call her the Inventor Lady herself, Miss Rita Crompton. Rita, welcome. How you doing?
I'm fine. How are you?
I tell you, I was just talking with you, and I know I say this every week, but it's like this week flies by so fast, you know?
Oh, I know. It's crazy. And, I don't like to admit it, but as you get older, it seems like time goes faster. And I know it's not really true because there is no science on that, but it seems that way, doesn't it?
Well, Rita, I got to take care of some business right quick. So don't go nowhere. Stay right there. We have some new members of our family that I want to mention. Again, we have that big, powerful station, WBTN 96.5 FM in Bennington, Vermont. That's now joining our family. And we have WGCH 1490 AM in Greenwich, Connecticut. And also, don't forget, on our website, we have episode 27, Matt DeGron with Aztec Washer. It's going to be talking different roofing components and systems. So check it out, HomeTalkTV.com. Rita, a lot going on. Got a great show. Let's just start this thing right now and jump right in it.
Excellent. I love to jump in. So we are talking today about intellectual property. You know, we do Invent America because America invents. And the more questions that we can answer and issues that we can help solve, the better chance the inventor has of getting through this really difficult and sometimes painful process. So everybody, I want to introduce today Malcolm Pipes. He's a registered patent attorney, past USPTO examiner. And just in case you don't know, USPTO stands for United States Patent and Trademark Office. We talk to these people on a pretty regular basis, and our inventors have to deal with them on a pretty regular basis. So Malcolm, thank you so much for being with us today and answering some really important questions for our inventors. So it is not unusual that you get down the road a piece and you end up having to talk to an examiner. Is that correct?
Oh, definitely, that's correct. Having communication with the examiner can be a very important step in getting your application allowed and having a patent issued. You have to request an interview, and you can talk to them that way, actually get a personal interview.
Right. So let's back up just a little bit and say, all right, so the first step is you file something. And if you filed a provisional patent application, that is never reviewed. So for our inventors that say, oh, how long does it take to issue? Well, a provisional patent application never issues. You just get notice like in 30 seconds or less that it's been filed and now you are patent pending. Then you have 12 months to file the non-provisional or the utility filing. And then somewhere within, 18 to 24 months, the interaction with the actual examiner begins. So when they assign then an inventor, Malcolm, to be the reviewing examiner, from the examiner's point of view, what are their steps?
It goes into your docketing queue. You have a docketing queue that has a list of all the cases assigned to you, and you're supposed to progress through that in chronological order. So the first thing you would do as an examiner is to open up the patent application, read over it, make sure we understand what is going on in the application and go through the claims, make sure we understand all the claims, review it for various technical requirements, and then we start the search process. And the USPTO has a number of databases in addition to the USPTO database of issued patents and patent applications. Technical sites you can go to and find prior art that reads on that patent application. You take a look at the claims, and then you find art that reads on those claims. Primarily concentrating on the independent claims.
All right. So when we talk about art, we talk about what's already been done, because a lot of our, our early stage inventors aren't really sure what that exactly means. We're not talking about the Monet hanging on the wall. We are talking about what has been filed in the past, correct?
It's whatever out there that exists that has been out there that you could have seen. And you don't have to have seen it. You can have foreign patents, foreign applications. Just had a rejection came in that relied on a website with a widget on it that read on the patent application that was at issue.
Okay, it's complicated. And so for inventors out there who don't understand, how many times can a patent be rejected by an examiner before you get that notice of allowance?
You can keep that patent application going as long as you want to. I think the record, whenever I was at the USPTO, they still had one that been floating around for 25 years. That was still in the process.
Oh my God. All right. So, a patent is only good for 20 years from the date it's filed. So if somebody can keep it alive for 25 years, you kind of beat the system, right?
Well, it ends up, what happens in that situation is you whenever the patent gets issued, all that time gets extended out. So you actually end up getting protection for a period of time. I think the minimum they require is like 17 years. I've forgotten exactly how that ends up working. Those usually only happen in the context of what they call classified patents. These are patents that are in some way classified by the U.S. government and are secret, and that can get bogged down into a fight, apparently, because 25 years is a long time.
Oh, Lordy, no kidding. I think the longest one that I'd had a client pending was 10. And that does not count our guest, Miss Cindy Duncan. So that was, one of the ladies that we'd helped early on, and she knew that it would be a long shot to get that patent issued. So she played the patent pending game and, got 10 years. And then she goes, okay, we'll file a design patent now. And she did. And, she had been in the market selling internationally for years and years, and I believe she still is. So, the more you understand about the process, the better off you are going to be getting through those steps to the point of, either being able to use the system to your advantage or finally being able to get patent, application. And so that's what we look for in those steps, is helping inventors understand what the options are and being able to get through the process successfully. So you told me once, and this is why we're doing this, because, we had this inventor who, was quite upset that, something in a foreign language had been found and it looked like they weren't going to be able to file anything at all. And that they, the conclusion they jumped to was that they should never have filed anything. But isn't that part of the kind of the rigged game, is that, they're supposed to reject things?
Yes, that is part of it. And there are just certain things that you can't get access normally, that unless you got specialized databases the USPTO has got access to.
So you don't really know what they're even looking at until they throw it back at you.
No, you don't have it. You don't necessarily, there's no way you can know all the technology that is out there. And I've worked on reexamination patents where there was an objection to the registration. And we went through, I remember I went through one of those, and we had over 4,000 pieces of prior art that were produced that we had to go through.
Wow. So I want you to stick with us. We're going to take a quick break here and in a couple of seconds, and then we'll come back with our guests, and then we'll wrap up with you when we're all done. I would like to take a moment to thank our wonderful sponsors, Kicker Design. If you are out there and you need to make a bump up, all right, and you need a manufacturer, please give me a call. On our website, you can access Kicker Design or Product Kickstart and be able to get out there and find the really good vetted service providers. And if you've got questions, join us at the Inventors Roundtable. The meetings are free. They are virtual. So all you've got to do is be sitting at your computer and log in. I answer my questions, I answer my phone, and my phone number is everywhere. Stick with us, everybody. We will be right back. Hello, everybody. Thanks so much for sticking with us. We are part of that HomeTalkUSA family, where we are helping inventors get from I have an idea to the marketplace, because America invents. And we are here working with you as Invent America. And we have got a couple of inventors joining us now to talk about their experience with the United States Patent and Trademark Office. And it is a long, drawn-out process. There is no doubt about it. Average, all right, on the good side is 3 to 4 years, and most inventors are really surprised to hear that, but it's just kind of the normal process. My first guest, Miss Cindy Duncan, I have known her for 17 years or so now, Miss Cindy, and met her when she was in a serious dilemma with dealing with the USPTO, but we managed to get through it. She has been not just patent pending, but had a patented product now for 17 years, which means we've probably known each other for about 18. So, Cindy, thank you so much for being with us today, and tell our listeners the very cool product that you invented.
I invented a type of chap. It's 2-in-1 chaps, and it's like a pant, but you can unzip what I call an insert. And when you unzip the insert, it looks like chaps. And when you put the insert back in with a elasticized zipper, they look like regular pants. So you can accessorize by changing out your inserts. And then you can also have the pant be leather, the insert be leather for protection as you're riding or on your horse. And then when you take out the insert, you can put in jean insert, and it looks like you're wearing jeans, chaps over your jeans, and yet it's only one piece. So it's much more comfortable for a woman, and she can go to the bathroom easier.
Well, yes, she can. And I've got to tell you, the first time I met you, we were at a meeting in downtown Denver, and you were demoing the chaps. You were standing on a chair and unzipping and zipping these inserts in and out. I thought all the men were going to fall off their seats and land on the floor. And you didn't even notice.
Remember, I walked the table as I unzipped them.
I know. You were so funny. And all these guys, I swear you didn't even notice that they were getting ready to fall off their seats. Because these things are really cool. And ladies, they are sexy. To the leather chaps, if you are a biker or a horseback rider, they really fit a fashion need that has never existed before. So, Cindy, since we're talking about the USPTO, you actually called. I was on the phone with you. We were able to call the examiner for you, and share with our listeners exactly how that went.
Well, it was kind of grueling because I didn't know what to expect, because I thought, well, how can I or you, although you're wonderful, how can we as a team seem to get over these hurdles when 2 prior patent attorneys had let it go abandoned, and they could never seem to get through it. But, it was so successful, and they were so helpful.
Well,
so
I think the big thing was that, and they kind of get their mind fixed on what they've seen in the past and what you present them based on the images. And the examiner that we ended up talking to, she hadn't really understood what you were trying to do. So we were able to email her the link, and it's really cool. Most inventors don't realize you can actually visit with your examiner, but you can. And we emailed her a link so she could actually see you demo the chaps. And then we were able to talk to her about it. And once we got done, it was like, oh, holy cow, I didn't even see that, didn't get it all connected going the right way. And I think within a few days, she had sent you a notice of allowance.
Yes. it just went very smoothly, and I was really grateful. So the thing is what I learned going through the process was that when you get a patent attorney and the claims come in, if they don't pay attention to them, your patent goes abandoned. So I had to take away that from them so I could be in control of my own patent. And then I spoke with the examiner, which is what made it successful. And that was all because of you and the examiner who was so patient.
So she was very good. And I've had inventors do that before, where we file the paperwork to do it pro se so that you can actually talk to then the examiner. And then we go back to the attorney because they're the ones that know how to write the legalese to make it correct. And so it's a matter of understanding really the paperwork and how to best utilize the skill set. I work with several attorneys now, and there's like, well, I talked to the examiner. And Malcolm's going to come back on and say, well, I talked to the examiner, because they do, because, a lot of times the examiner cannot read your mind. And a lot of times, because you've got to you can't put in the application a video, and you can't put in the application, somebody demoing the product. It's got to be black and white drawings, and the black and white drawings don't always tell an accurate picture.
That's true.
And it wasn't until we actually were able to send the video link to the examiner to her email, and she was able to see it. And she goes, okay, I had that one all wrong. And she was great about it. They're human. They are human. And as much as they are taught to play a game, which is, where I get irritated, they're taught to have so many denials. They get points for rejection. And most inventors don't realize that they're just caught in I don't know, a pinball machine of getting batted back and forth. And it's really, it's tough when you don't know. When you know what to expect, you can say, oh yeah, saw that one coming. Oh yeah, knew that was going to happen. And it certainly makes it easier on your digestive system.
So it does.
So what are your goals, Miss Cindy? What are you looking for?
What I'd like to do now is, I've gone through a lot of manufacturers. So what I'd like to do now is get one that can actually give me a good prototype, which is another process inventors will learn is very difficult. And then I just need to market them. But I want to be able to get a prototype that will not produce a lot of returns. So that's where I'm looking at. And I've got many prototypes in the past. And that's my goal now, is to get the latest manufacturer and get a quality prototype.
So, and I sent you the name of John Thompson there in Denver with Fruition Labs. He's looking forward to chatting with you. Yeah. He did the Float No More prototype for Wendy that you saw at the ASD Market Week show. So, and I thought it would be good that he's right there so you can go and see him as a textile manufacturer. So that'll be good for you. So everybody, we are getting ready to take a quick break. We got to go pay some bills, and then we will come right back. But in the meantime, all right, what we want you to know is that we help inventors every day. So when I get inventors on a Saturday afternoon when this is airing and they're calling me and I go, how did you get my number? And they go, you're on the radio right now. I do answer my phone even on a Sunday afternoon or a Saturday afternoon. Happy to help answer questions. And that's one of the things that we do at the Inventor Roundtable meetings. It's kind of the call-in version of the show. And, inventors from across the country can meet each other. They can meet some of the service providers that we have vetted and offer up. And there are a lot of steps that go into this process. And the more you know, the better your business decisions are going to be. So when I get an inventor that says, this is where I'm at, and he goes, I didn't know you existed 5 years ago. It's like, oh, I have been here. All you have to do is Google Inventor Lady or Invent America. And we are there, and we're there to give you answers, help you find the right guys, and really, see your dreams come true. Because you know what? Almost everybody's thought about being an inventor at one time or another. Everybody. I've got an idea. What do I do next? And so we help you get that out there. Stick with us because our next guest, his patent has issued as well. And we are going to be able to talk to him about his steps and what he's got. It is a very, very cool idea and product. Stick with us.
And now, back to Invent America from the #1 home improvement radio program in the country. Home Talk USA with your host, the Cajun contractor Michael King, and his co-host, the Inventor Lady, Rita Crompton.
Hey, everybody. Thank you so much for being with us this afternoon. I hope you are having a wonderful weekend. We are talking about the USPTO and the challenges. Not everybody has a negative experience with the USPTO, and the more you know, the better your expectations. And the better it is to, I don't want to say, let's just say manage the system, as opposed to some of those negative words that we could use. We want to be able to understand and manage the protocols, which is exactly what they are. So my next guest, Craig Bush, has had over 25 years experience with the athletic performance training industry. He has invented a new product called RepUp, and he is going to tell us, what does that do, Craig? Why is that important to trainers?
Rita, thank you for having me on. Yeah, I've been in the athletic performance training industry, as you said, the last 25 years as a pro skills basketball trainer. So essentially what I've invented is I've infused technology for the first time ever into agility cones. And what that means is that you can take an athletic ball, any athletic ball, there's over 85 athletic balls in our USPTO patent, that can trigger a stopwatch and a rep counter when it's released from an apparatus. So in my case, I took a standard agility cone, put a display module on it, and as soon as a ball is released from that cone, you can time, count, and then track that athletic performance through an app.
Very cool. Why is that important?
Well, everything today is moving forward. Technology is the number one thing. And that's why I actually went to the USPTO first and looked to get my patent. But it's very important. You want to be able to track your progress. So if I have an athlete that's a beginner level player up to an elite level player, we want to be able to track performance. We want to know where they start, where they're going, and then all of the in-between data. And so once we have that data, then we can show true results on how athletes are performing and progressing. So it not only helps the athlete individually, but it helps the coaches, the organization, and it's just a great thing.
Excellent. Excellent. So when you were working with your registered patent attorney, you did a couple of rounds, to say the least, with the USPTO. So explain a little bit about the process that you had to go through and how did you finally win?
So Rita, I want to encourage your listeners right now. This is a wonderful platform that you have. I didn't have that platform or was not aware of you guys. So I certainly wish that I would have had a little bit more information before I dove in. But what I wanted to say is mine actually took 3.5 years with 5 rejections. And so, how do you respond to rejection? It's not always easy. So I want to encourage the entrepreneurs and inventors out there to just stick with it. My attorney was super encouraging. So at no point, Rita, in those 3.5 years, did he ever say, Craig, I don't think we're going to get approved. And so that's what kept me going. And the other thing that I would say is you don't want to assume anything because you never know what's going on behind the scenes. And the other thing is that the examiners, they're not going to tell you specifically what you need to put in writing to get it approved. So that's the game. So there were many times that my attorney and I would be on the phone and, he would be asking me questions. I'd be asking questions. He's like, what do you think we do? And many times I just have to say, hey, I trust you. You're the expert in this field. I'm going to let you roll with it because I trust you. And so try to find those attorneys that you can put, great faith in and have confidence in, because if you do that, it will make the process much smoother as you get it rejected.
Yeah. I tell inventors, it's like, you're doing a dance with the USPTO or a tug of war, depending on your frame of mind on any given day, to try to get it through, but it's a give and take. And so when we say rejection, it's kind of like using the word discipline. It's not necessarily a punishment. It's protocols, boundaries. And so they're not necessarily saying, oh, you're rejected. They're saying, you can't use it this way. And so we look at the office action, and I think a lot of them saying, well, rejection, and that's the word that jumps out, as opposed to, no, you can't do it this way. You need to find a different way to do it. So it's subtle. And, most inventors, especially our independent inventors, it's not like you've got years of experience doing this. You've got 1 or 2.
And it's just having that confidence in your product, because, the listeners need to be aware that every time you have to resubmit, you have to pay fees to your attorney. So you need to be prepared to be able to do that. And so that can get very, very frustrating. So you just got to get out there and keep working.
Well, and that's one of the things I've told inventors is, a good registered patent attorney is not always about the hourly rate. Sometimes it just means they drive a nicer car. And so you can find a good registered is the key word there. And I never recommend that an inventor go pro se. It's one thing, like Cindy was saying, we did the paperwork for her to be able to talk to the examiner and we could talk to him. But then she went back to a registered patent attorney when she was done with that and got the registered patent attorney back involved. So, there's some subtle things that we can do on our side with the inventor or as the inventor. And then, you use that registered patent attorney because they know how to word it. And it's just like, Malcolm said, I was an examiner for years. I know what they do. I know what they're taught to do. And so having that experience is really the only way to go.
Yep. And when we started off, we went ahead and we made it as broad as we possibly could, knowing that we were going to be rejected. But we decided, let's go big here and see what we can do with it. And then you just start narrowing it down and chipping it away. And then eventually you'll get that issuance notification. So. Yep.
And we have a gentleman last week, he just got his notice of allowance. And so when, we hear that, only about 56% of the inventors who apply get approved, it can be very discouraging. And especially like, the one inventor that I had talked to, and she was so upset that she had gotten a rejection. It's like, this is only your second one. I'm really not understanding why you were so surprised that you got another one. I always tell people to expect 3 or 4. So when we can do it in 3, that's a win, but you just never know.
That's right.
Share with our inventors, what is your advice to them? Do you have another set of, things that you can give them? And then share with us, where do you want to get to?
My long-term goal is obviously to get my invention to market. That's been a long process. It's been a long journey. Now that I have the patent, I feel very confident with it. And so our next step is to start to get exposure and start to get the word out, just like we're doing right now, because a lot of people don't know what it is, or a lot of people don't even know that we've invented something.
Right. So we are going to post your website so people can get out there and see it. Give everybody your website. So if they have a chance before we post it to go and look, they can.
Sure. It's www.cb3elite.com. cb3elite.com.
All right. And we're going to
really neat demos on there.
Okay. We're going to get you on video so people can actually see you. And then we're going to share with them directly the website and get information out there. I know you were working on a sell sheet, so we can get that down and what a licensee would want to read on that sell sheet and get that out there to them. Start getting all of that stuff posted so we can get some good visuals for people. Because, it's one thing that, that we've got you talking and sharing all across the country, the experience, but we really want to be able to share with folks a little bit more about your specific story. Because I think that, the radio gets everybody intrigued and it's like, oh yeah, let me hear more about that. And we try to offer that option to our inventors and listeners through some video, and also then on the Inventor Roundtable meetings. The meetings are free, everybody. All you've got to do is just go to the website, find the link, and log in. We would like to see you again and be able to get you back on. So any last advice for our listeners today?
Just stay patient. Be patient. The process it's a marathon. It's every day you just keep chipping away and never, ever, ever quit. Put the right people in your corner. Surround yourself with like-minded people that are positive encouragement, that are positive, and stay encouraged. And then never not believe in yourself. Know that there's a reason you're doing what you're doing, and the only thing that would be holding you back would be yourself, honestly, because it can be a lonely battle, like you're on an island by yourself.
I've had so many inventors tell me that they just felt like they were all alone. And, it's funny because sometimes they say, get some testimonials on your product. Your mother doesn't count. But then on the other hand, when everybody in the family thinks you're crazy, that doesn't count either. So there's a sweet spot to be traversing through the process. And a lot of times it's, groups like the Inventors Roundtable where you can actually come and visit with other folks. You can hear the problems that they've had and be able to, get things out there as far as questions and make good business decisions. So I want to thank you so much, Craig, for being on. We will get you back on again because you've got a lot of good experience to share with our inventors. Stick with us, everybody. We are going to be back with our industry expert in just a minute. Thanks, everybody, so much for being with us this afternoon. We are talking about that very touchy subject of the United States Patent and Trademark Office. It's kind of the be-all and end-all in getting a patent issued, and understanding the process certainly gives you a better chance. Our industry expert today is Malcolm Pipes. I've known Malcolm for about 5 years now, and he has helped inventors get through that really difficult process. And Malcolm, thanks so much for being with us today.
Well, I'm glad to be here.
So you were an examiner, which is a wonderful asset.
Yes, I was an examiner.
So why does an inventor get so many rejections?
One reason is because of the point system they have built into the system. You get so many points for taking some different actions. Issue rejection, you get points. Issue an allowance, you get points. And the point system is tied in to getting bonuses on top of that. In other words, you have a goal. If you hit 110% of your, or I should say quota, of your quota, you'll get a bonus. And if you perform below a level, you'll get dinged for not meeting your quota. So there is some of that gaming that goes on. I had a supervisor who had a policy that we were not to issue a allowance on the first office action. In other words, we had to issue a first office action even if we thought the application was allowable, which you're not supposed to do. But it's tied back in to the point system. So that is one reason. Examiners will game the system by basically throwing out a rejection when they know it's allowable. And then all they have to do is wait until the person comes back in. Then they issue out an allowance without having to do any real work because they already know, hey, it's allowable. I don't really have to do anything. Put their reasons for allowance in that, that it doesn't teach this particular feature, and call it a day, and they end up getting more points than they would have if they had just issued the allowance for.
And it's so many of our independent inventors really don't understand I don't want to say the system is rigged against them. It's a rigged system, but it's protocols. It's what they're supposed to do on their end in work. It's basically work protocols that the USPTO examiner is dealing with, correct?
Yes. I mean, the bottom line is there's a lot of technology out there. There's a lot of prior art that is floating around. And as examiner, you have to put it together and, hey, is this an allowable invention, or is it taught by a combination of other things that are out there in the public domain? And I don't want to make it sound like the entire process is corrupt, because it really isn't. I mean, you have to make good faith effort in going through and getting that information together and come up with good rejections. And that whole process can take a while. You have to have the give and take going on between the inventor, the patent attorney, and the examiner on, hey, is there something we can do that will make the application allowable? And every now and then you have to, quite frankly, do a CIP, continuation in part, where you amend the application to add some other little features to it that you came up with, or some new ideas that you have to overcome the prior art that he has produced, and put that back in front of the examiner, a new application in essence. And that way you can get a lot of times get an allowance and have a patented invention. But there quite frankly is a lot of inventions that in the end are not novel and are not patentable.
Right. Right. I mean, we try so hard to make sure that we explain things early on, and that, there's a difference between, oh, this is a new, better widget as opposed to what is new and novel, because that is what the examiner is really looking for. But explain to our listeners kind of we've seen things be very subjective in the patent process as opposed to objective, because, everybody's human. All right. And they bring some of their own thought processes with them. Help us understand that a little bit better.
Well, one of the problems I kind of noted in a way is that workforce of the USPTO is fairly diverse. So you have a lot of foreign-born, educated patent examiners than in the USPTO, which is good on the one hand because they bring a lot of expertise from their different countries a lot of times to the office, and are more familiar with the databases that are available overseas they can go to and find things. But they have some cultural baggage that comes in with them as well. So
Right.
Every now and then you run into a cultural barrier that is really nobody's fault. It just is what exists.
Yeah.
And you kind of touched on it, that every now and then they just don't get it.
Yeah.
As examiner, we read it one way when you mean it another. And the only thing that you can do in that case is, hey, you need to change this around. Well, sometimes it could be as simple as a misinterpretation on a definitional word as far as how the examiner is looking at it, because the inventor can act as their own lexicon. You
Mhm.
can invent your own terms. Well, if they don't get that whenever they read the patent application, they're misinterpreting the term that you've got in the claims, and they have no clue what you're really claiming because they haven't gone through and haven't really paid attention to the terms in it.
Yeah. And like with Cindy's, the examiner kept thinking diaper as opposed to chaps. And so when we got her on the phone and showed her the video, it made a huge difference. So Malcolm, thanks so much for being with us today. We're going to, we've just got a little bit of time left. I want to encourage inventors. If you've got an idea out there, all right, find out about what the early steps are that help you make better decisions. Use the right service providers. Check in with us at the Inventors Roundtable. Go to the Invent-America. Fill out the form. Be on the radio. Join Craig and Cindy as part of our audience and presenters. So if you are an inventor and you've got questions, you've got an experience that you want to share with everybody, guess what? I get to pick the topics, and I would love to have you on. So Invent-America, everyone, and we will talk to you next week. Have a great week, everyone.